we can talk to you about this case. I know it's been a long couple days waiting for us to finally get here, so the moment's arrived. Why are we here? We're here because of the defendant's conduct. Conduct is words and acts. His words and acts directed at a witness and directed and touching that witness's family. He is charged with witness tampering. Witness tampering in New Jersey requires that a person know an official proceeding is pending against them, and that they then knowingly engage in conduct. So that knowingly means that they understand exactly what they're doing. If they say something, if they do something, that they know what they're doing. Then, it's to consider from a reasonable person's standard. The law requires
It was 2 minutes ago.
That's God. Thank you, God.
Now,
Jesus.
All right. Forget it. You don't need to see it. You don't need to see it up there on the screen. If the defendant knowingly engaged in conduct that a reasonable person would believe would cause a witness to testify falsely, meaning to lie, to withhold testimony, meaning refuse to testify, to absent himself from an official court notice to bring him to court, meaning to avoid the service of process, or to, after receiving process, just not come in. If that conduct would cause a reasonable person to believe a witness would do that because of that conduct, that's witness tampering. It doesn't require what the defendant's intent was. It requires what a reasonable person would believe would result. So what did he do? Why are we here? Well, in this case, there was an open case against the defendant, and there was a witness. And the state filed a motion for a protective order to withhold the identity, address, and name of the witness for a certain amount of time. That was filed August 19, 2016. With that motion pending before the court, the defendant, on August 22nd, gave an interview to the newspaper saying, I'm going to give this person up. He then went on his Facebook page, linked the newspaper article, and put it out there. That's all he did, we wouldn't be here. Now, what you have to know is that the defendant at the time had multiple social media pages. He had Twitter, he had Instagram, he had Facebook. And on those social media pages, he had about 15,000 followers in the aggregate. So he posted that. On September 8th, he posted another posting indicating that he knew the identity of the witness and that he was going to put it out there before the court could rule on it. That's all he did. We wouldn't be here. Thereafter, he posted a video saying kind of the same thing relating to a webpage he had. So in addition to that social media platform that he had, he also had a webpage, and he linked that webpage. That webpage went to the video where he explained what he was going to do. I'm going to put this witness out there. I know who it is. That's all he did. We wouldn't be here. On September 12th, 2016, he posted a photo of the person he believed to be a witness, as well as the name he believes is the person. And he told his followers, be on the lookout for this guy. If you see him, post his photo on this page. Put it on there. That's all he did. But he wouldn't be here. On September 14th, he gave another interview to the newspaper. In that, he was asked a question. And he said, if you asked me straight up, would you do 7 years or let this guy get shot in the head? I'd let him get shot in the head. My concern is beating this case by any means necessary. Even with that, if that's all we did, we wouldn't be here. On October 7th, the defendant went to the federal courthouse attorney, and he looked up information about the witness. He found his name, his true name. He found his prior address. He found the last 4 digits of his social security number, his wife's name, the last 4 digits of her social security number, and decided to take screenshots of the information he found and posted it on his Facebook. He also posted a picture of what he believed to be the home phone number and the cell phone number of the witness's wife. He also posted a picture of the phone number that he believed belonged to the witness. After that, he went to his Twitter account and he posted a Twitter link, basically putting out a link, put a post on Twitter that linked to his webpage, which he now created, that posted some of that same information, the last known address of the witness, the information about his wife. And it also included information that his kid may be autistic, what kind of cars his wife drives, what kind of car he believes to drive, and the fact that he may, at that point, reside somewhere in Plainsboro, and intimated that he was looking for the real address of that person. Now, in addition to that, the information he had posted on his website, he then, a few days later, on October 15th, mailed documents. He sent a package to the witness's father at his home. Address to the witness's father, a certified mail document. On the front of that envelope that he sent, it was his address, as a return address. It was addressed directly to his father, mentioning care of the witness. And within that package were a certain number of documents. First, there was a handwritten note to his father. The handwritten note to his father indicated that he was to give the witness the contents and the package. Give him the contents of the package, as well as giving him shit for being a rat. He included a copy of the lawsuit. He included a picture, the same picture he had been posting previously on social media of the witness. He included the newspaper article that he had been quoted in saying he was going to sue the witness. Provided that all to the father. A few days later, the father gets sent down with the package. Same kind of envelope. This time, didn't have a handwritten note as to who it was from, but it included another copy of the lawsuit, the picture of the witness, this time with the writing that you'll get to look at when you see it, and another copy of the newspaper. Short time after that package arrived, father. The defendant began to post again on Twitter, and this time it was the photo that he had been posting before, now including the phone number of the person he believed to be the witness, and some writing that indicated he was a CI and a rat for the Trenton Police Department. Thereafter, on October 18th, he posted a message, a video on his Facebook account. The video, and you'll see it, he basically admits to mailing the package to his father. He flashes what looks to be a certified mail receipt. He laughs about what he did. In that posting above it, describing the posting, he lists the federal tracking number of the package. He says in the posting, I served it on his father today. He got served. I could have served it on his mother. And then he puts initials next to that and a name Elsa. You could have served it at him as kids when he was taken to school. After that post, he continued to post things on Facebook showing the witness his phone number. And then on November 8th, I believe, November 8th, 2 letters go out from the Trenton area post office. The first letter is addressed to the witness's mother-in-law. And it's addressed to the witness's mother-in-law, handwriting on the front, with a supposed return address of the witness's sister-in-law, who lives in South Carolina. That first package that arrived at the mother-in-law's home, it contained the very same information that was on the defendant's website, where he indicated, in effect, that they knew the last known address, the cars that the family used, the fact that the child was autistic, or that he thought he would be autistic, the information relating to where his current addresses might be. And then it had a disclaimer. Disclaimer said, we're only looking for information. Others may feel differently. We're only looking for information. And that was sent to his mother-in-law with that return address, even though it was mailed from Trenton. It also included a copy of the article that was sent to the father-in-law with the tracking number scrawled in handwriting on the newspaper. Now, a few days after that arrived at the mother-in-law's home, an identical package, including one other document which appeared to be a FedEx receipt for copying documents, was sent to his sister-in-law in South Carolina. This time, the handwriting on the front, even though mailed from the Trenton area, had his wife's name. So what is his wife's name as the return address? Again, with the same information relating to the defendant knowing where information about the family, where their last known address was, what kind of vehicles they drive, and indicating to Google the witness, calling him a rat. On the week of February 8th, more mail arrived. This mail arrived at the witness's residence, where his wife resided, where his mother-in-law resided again. This time, it was a white envelope, no return address. No return address at all. No addressee, just to the residence. In that mailing, there was information purportedly about the witness indicating he had been arrested for certain offenses in various areas, indicating that he had a drug problem, that he was cooperating with police. And attached to that information was a flyer, which appeared to be something from the Bordentown Neighborhood Drug Watch. I'll tell you now, you're going to hear that that doesn't even exist. And it was sent to the family. They received the first letter, had marker. That's how it was written on the front. And that's the information that was provided. It was information directed about the witness, alleging that he had other offenses pending, and that it should be coming from the Bordentown Neighborhood Drug Watch, and that people should look out for this guy. A couple days later, another envelope arrives, the same information, except this time it's handwritten in pen on the front. This isn't signed. The front of that document indicates a press release naming the prosecutor of the case. To Ms. Katz, my press release. No salutation, no signature on it. But on March 3rd, there's a search warrant executed on that address that was on that first package that was sent to his father, 322 East State Street, the defendant's business. It was there in his office was white envelopes with the addresses surrounding the same address the witness was living at. So that was 9 Deerfield Court, 10 Deerfield Court, 11 Deerfield Court, 12, 13, 14, with the same information that was sent to the family. That is the state's case. The state's case is the defendant's words and acts. And your job in this case is to decide, would a reasonable person believe that those words and acts would cause someone to testify falsely, to not want to testify, to withhold their testimony, to avoid being subpoenaed to court, or after being subpoenaed, to not show up. You're going to take that from a reasonable person's standard. You to evaluate that objectively. Think about that information. What effect did that have? That is solely your job. Now, if you come to the determination that that would cause somebody not to do one of the things, to testify falsely, not show up, withhold testimony, or avoid the service to come, you then must consider whether the totality of that conduct amounts to a threat. Would an ordinary person believe that was a threat? You're not here to judge what the defendant's intent was. You're to look at it from an objective person's standard. Look at the information they provided to you. That's why you were picked. You were picked because we thought you could be objective. Everybody had decided to do the jury to make that assessment. I'm confident when you look at the entirety of this case, and his words and acts, you'll make the only reasonable conclusion that a reasonable person would believe that would cause somebody to not want to come in and testify. We'll talk to you in the case.
Thank you, Mr. Chairman.